Hey everyone, and welcome back to our video series where we break down trademark law so that you can make the best trademark choices. Previously in this series, we've talked about the history of U.S. trademarks and everything you need to get registered with the USPTO. Today we're going to deal with what happens after registration. You finally got your trademark and you're ready to take your baby home. But just like with any child, your trademark will need a lot of TLC from this point on. There will be late nights, tantrums, fevers, and messes, so join us as we teach you how to be a responsible trademark parent. First off, you need to make sure you keep using your trademark. If you neglect your trademark and you can show no proof of use for 3 years, this will be used as evidence of abandonment. If you abandon your trademark, the USPTO will issue a non-use cancellation on your mark. Another thing you need to protect your trademark from is revocation. Now things will be different depending on how old your trademark is. If you have not yet reached its 5th birthday, your trademark could be canceled for any of the reasons it could have failed to register in the first place. Or if the continued use of your trademark will be damaging to an already existing trademark. I know what you're thinking. If there are issues with my trademark, then why on earth did the USPTO issue my registration at all? This just shows that in a busy, complex, thousands filed world of U.S. trademarking, things can get overlooked and there really are no guarantees. The best thing you can do is make sure your application is as solid as possible before filing. Now, if your trademark has reached its 5th birthday, things are a little different in terms of what constitutes a cancellation. The grounds for cancellation are your mark has become generic. Think about escalators and zippers. These were actually trademark names for those items, but the trademark was lost once people started using these terms as the actual name for the product itself. Your mark is functional in nature. It just describes what your product does, like window wipers. Or as discussed, your trademark has not been used for a long time. There are other reasons too, such as your application was fraudulent, or your trademark is deceptive, immoral, or compromises of a name, etc. But we assume good faith on the part of our listeners, so most likely you would be dealing with the first 3. If there is an issue with your trademark, here's what will happen next. The other party will file an electronic petition for cancellation with the Trademark Trial and Appeal Board, also known as the TTAB. The petition must be signed by the petitioner, that being yourself, or their legal representation. It must also outline the ways the petitioner's trademark will be damaged by your trademark or other trademark and the grounds for cancellation. The other party need only send you fair notice of the filing unless they are accusing you of fraud, in which case they need to provide you with the particulars. You will have a chance to respond to the petition before the commencement of discovery, trial, rebuttal, and expert analysis. Let's say the worst happens. Your trademark has been canceled. Your baby has been ripped out of your arms. That's a little bit of a depressing image, but snap out of it. There is something you can do. You can head straight to the U.S. Court of Appeals for the Federal Circuit or Federal Circuit District Court. That has jurisdiction over both parties. Well, don't head straight there. There's a bit of procedure to follow as usual. In general, you have 60 days from the time of cancellation to appeal the decision. If you choose to appeal to the Federal Circuit, the other party has 20 days to have the decision re-examined by civil action. If you appeal via a new civil action, the court may decide that your trademark should not be canceled. So there's always hope, people. Remember, the best defense in this situation is to not have done anything wrong in the first place. So make sure you work with experts like Witmart when you file your trademark. So you've done the changing and the burping and the pacing at 3 a.m. You fed, cuddled, and tucked and soothed your trademark in its infancy. Now your trademark has developed their own personality and is doing so much more on their own. But then another disaster strikes. Someone has infringed on your trademark and you're in a full-on custody battle. Next, you have to move to protect your trademark. You need to head to the federal or state courts to file a suit for trademark infringement. You will need to prove that you are the bona fide holder of your trademark, therefore within, they call it the zone of interest. That the other party has been using the trademark in the sale, distribution, and advertising of goods and services. That their trademark can be confused with your own, and that this confusion, infringement, is damaging to your business. If you are successful and if your case is strong, you will be. There are various compensations you can receive. The most common is injunctive relief. If your business has suffered a permanent injury that cannot be fixed with monetary compensation only. This will prevent the other party from continuing to use the infringing mark in business. As for monetary relief, there are a few different kinds you can get depending on the particulars of your case. There's a repayment of losses, the profits made by the defendant using the infringing mark, court costs, and corrective advertising. One thing you have to keep an eye on is timing. The federal courts in the United States do not provide a specific statute of limitations for infringement cases, but they will refer to the state statutes of limitations. If the court finds you guilty or of laches, having delayed your lawsuit for any unreasonable amount of time, they may determine that this was an attempt by you to create prejudice against the defendant and you could lose the case. Also on the subject of time, court proceedings tend to be long and drawn out affairs. It can take anywhere between 6 months and several years to reach a verdict. In the meantime, you can protect yourself by filing for a preliminary injunction or, in urgent situations, a temporary restraining order. This will prevent the other party from conducting business under the trademark for the duration of the lawsuit. Now let's put the shoe on the other foot for a minute and say you are the one who has, according to the plaintiff, infringed on their trademark. There are a few defenses that you can use, and including these are the laches. As we said, this is an unreasonable delay of the plaintiff in the filing of the lawsuit. Another defense is unclean hands. This defense is used when you can prove that the plaintiff has acted inequitably or illegally during the case. And then there's another defense of fair use. You can claim classic fair use by saying the plaintiff's trademarks are merely functional and descriptive, or you can claim nominative fair use by asserting that you only use the trademark to advertise the plaintiff's goods and services and not your own. Amendment-free speech. While not a legal defense, this is a way to argue against likelihood of confusion if your products are meant as a parody or self-expression. If you lose the case, you can appeal, but if you really are in the wrong, it's unlikely they will reach a different decision. The best thing, of course, is to be extremely careful to avoid infringing on anyone else's marks. Raising and taking care of your trademark is exhausting, but also fulfilling, and in your golden years, you will reap the rewards when your trademark takes care of you. Legal action is a nuanced subject, and you will always have questions. For more information or a free consultation, visit our website at tm.witmart.com or give us a call at 1-877-948-6278. Thanks for listening, everybody.